Fruit of the poisonous tree. It's a doctrine in law. It deals with what they would deem to be an illegal search. What's kind of hard to explain at times on this subject matter, because I'm going to try to relate this to when the parents were filling in the statement of birth record at the hospital. Because we've already gone over the law, at least in Canada, that there is no provision in the Canadian legal system for an individual to transfer. That means convey, speak, write their given names to anyone, whether to a person, a corporation, or a trust. And any document that would purport to do so would be invalid. That's why the statement of birth record cannot be used as identification in Ontario if it's been issued out of Ontario, because basically it's not consensual ID at that point, because the very fact was that the given name is purporting to be transferred when you look at the surface or the face of the document. So on the surface of the document, it appears that the given name and the surname are on there, but it actually means contrary to it. If anything, as we know in Section 15 of the Ontario Vital Statistics Act, it talks about a scenario of either the legal parent consenting to put the given name on the document or the forename into the birth registration system, or the child whose given name was never placed in there to consent at age of election to place it in there, then pay the appropriate fee, and then receive a birth certificate. But in the requirements, the only thing that was required on this document was actually the registration name. Now, I don't have a copy of a particular birth certificate uniquely that was issued, but it only states the last name of the child. Therefore, if I'm talking about a last name Smith, it's baby boy Smith would be on the certificate, because that is the registration name, not the given name. So when we're talking about the doctrine of the fruit of the poisonous tree, now that's what it is known in the United States system, but Canada has another name for it under the Evidentiary Act. But when we're talking about the fruit of the poisonous tree, it's actually searching for something that they don't have the right to search for. So when you look at, there's documents you can obtain from some offices of the Registrar General in some of the provinces, and what is called a birth search. And in the birth search, of course, it never says given name and surname, it just says name, and then the name in reverse order. So it's done like that as the birth certificate to clearly look like they didn't really do an illegal search or a non-legal search trying to get the non-legal name, which is the given name, into the record. So when they're asking the parent for that, it actually really is almost like this doctrine of the poisonous tree. They're asking for something that they don't have the right to ask for, but they're asking for it anyways and inducing its registration into the document or being added in. So it's a unique thing, but remember the laws that are, especially English laws, and especially in Canada, in the US, we have an accusatory system of law. So you're deemed to be guilty, okay? You're not innocent until proven guilty. You're guilty until proven innocent, because it's already deemed that you're already going to be claiming and using the surname. Therefore, it being a debtor, you're automatically in guilt, sin, debt. So this innocent until proven guilty is kind of a crazy concept in the system that we live in. So had that been just filled in where the given name was non-transferable, which is what the case proved under, basically Regina or the Queen versus Paparella, there was never a provision in the Canadian legal system that could demand or make somebody transfer or place it or convey it on any document or legal instrument. Remember, this is a permanent legal document. It has nothing to do with reality or spiritual truth. So therefore, it has to remain in fiction. And therefore, now we understand why the given name wouldn't even appear on there. So it would just be an unknown factor, because without a given name on there, they don't have someone hosting the event in the future as the surety. And therefore, they have no trespasser. So there's no one to fee and fine. And because that individual would be being trained as a spiritual individual, even though the parents may have been in the contract, the legal contract, they certainly did not have to doom their children into it any further. So I'm hopeful that I'm getting through to people that are in the midst of the birth registration system, many of them being done at home births. Watch out for the midwives, because they're the first ones that are already going to know the given name of the child, because they've had a more close contact relationship with the birthing mother, and therefore they're going to stick that right in on the Form 1 document. Whereas if it had just been as it was done at the hospital, the attending doctor had no idea what the name of the given name of the child would be. Therefore, that's why it was always just the surname was only known at that moment. You've exposed the privacy of the child into the public at that point, and then therefore you're inducing them to follow that direction. So it's a very, very factual process we've been actually explaining, even though we're dealing with the fictions within this, but we're breaking it down so it's understood. And without these type of videos out there, I just feel that the audience is walking around blind. And I'm surprised that I don't find many videos from people dealing with this in its direct targeting. Let's get down to the basics on this. Let's find out how this works. And so people are jumping in the middle of things in the legal world, but they don't even understand the foundation of where it all began. So do we get this now? Do we understand it? Are we getting closer to realizing that you would not have been carrying or bearing a surety for this had your parents been more spiritually aware? And then they would have been making, of course, directions to get themselves out, because the minute you stop suretying it, this legal bond is going to go back to whoever is basically responsible for it at that point. It's kind of like frustrating the contract. So therefore the issuer, which would be the province or a state, would be responsible for it, just as they would be when you go around using it, because they're really the surety. You're acting as the guarantor, but in reality they're co-signing or co-suretying everywhere you go, but you never mention them on anything you sign. You're always basically acting as the one until you decide to default. And of course, their system has a wonderful way to allow someone to go into where they give up, they can't pay the debt anymore, and they go into bankruptcy. And when they do that, basically it takes them 9 months before they actually rebirth this child again and take the bond back and redo it all over and do all the bookkeeping on whatever has to be done. But you're in 9 months amazing gestation period during that to go back out into the commerce again, so that you can surety again this baby bond. So I'm doing my best, my utmost to try to explain this simply. And the best thing to do is go over the videos, slow it down if you have to, pause it, make notes. It'll start, and then get a board like this and start, drawing out the picture. Because when you're able to do that, then you're going to start seeing this more clearly. You'll start to have eyes to see and ears to hear, and you're not going to be walking around like the legal blind.